Good afternoon, everybody, and thank you for coming. My name is Marco Marques. I'm a business developer for the Virtual Forge, also focusing on cyber and the GDPR. I have to apologize for my accent. As you may have understood, I'm not English. I'm Portuguese, but I will introduce Matt shortly, as he will our brilliant main speaker for today's seminar on the GDPR. Um, so we will also have Crystal Pennington. She is the CEO for NeoRM. NeoRM is a software platform for risk management, and Crystal has a very solid background also in compliance. So Crystal worked for 20 years for an equity company, equity trader company, and she understands more than anyone how companies need to be compliant and what is the risk if this compliance standards doesn't meet what is required for. So the Virtual Forge, we are a disruptive technology company focusing in software development, quality assurance, design, AWS, and cybersecurity. And within the cybersecurity, we also not only we focus in penetration testing, understanding how companies should implement every guidelines to be solid and resilient, consider the demands, but also towards the compliant segment, which is included the GDPR, which was also a logical path to follow, since some of our customers were starting to have some concerns on the regulation that it's going to come into force in 2018. And the way we approach this, it's actually a three-way approach. We first understand how the data is organized and what actually should the customer do in order to make it compliant towards the governance that needs to be put in place. The other thing that we actually do, and since we are a technology company, is understand the levels of security that are in place and what should actually the client or the customer or partner do in order to increase their security, avoiding therefore data breaches to occur. And lastly, governance. So we actually understand the privacy policies that needs to be put in place once again. And if they don't meet the requirements, we can help you achieve the standards. So this is some part of what we are going to discuss today, meets what I've just said. We are going to start, well, Matt Wicks is going to start right away. We'll go through the background of the regulation, the basis, the principles, and the rights of data subjects that come as one of the biggest changes to the previous directive, and how actually this is affecting the business operations for the companies to continue to be compliant and avoiding not only huge fines but also lawsuits on the follow. And as the afternoon goes by, we will approach the DPO. What is the DPO? What is the data protection officer? What is the role within a company? Is it really necessary? And how good is it to have one with ourselves? And lastly, law basis, and if you have operations overseas as well, the transitional territory amendments to the previous directive. This is something that we are also going to cover today. So Matt, I don't know if you want to start right away. I'll be also here if you have any questions and supporting. All over. Okay.
Thanks very much, Marco. And thank you to everyone for coming. We really appreciate you giving your time to come and listen to us, or me, speak. And also to everybody who's watching this, we also have a live stream available, which is being broadcast as we speak. And that also means that there'll be a recorded stream of this after the event, should you wish to access it. Most importantly as well, we'll be around at the end of the session to pick up, have conversations, delve a bit deeper if anybody wants to delve deeper into this. One kind of small housekeeping note is that there is a Q&A session which we'll have at the end of the session. If I could ask you to keep your questions until the end of the session, obviously please do note them down and keep them kind of fresh in your minds. But if we could keep those to the end so that we can get through what is an enormous amount of material this afternoon, I'd be very grateful. So as Marco said, my name is Matt Wicks. I'm the co-CEO of the Virtual Forge. My responsibility is for technology and innovation. That means that I'm approaching this from the perspective of a technologist rather than from the perspective of a legal person or from an accountancy perspective or anything like that. My responsibility within our organization and the way in which we approach working with clients on GDPR as Marco said, is very much from a what can we do? How can we help? How can we solve the issues? What are the real issues? What practical things can be put into place? So this afternoon, I'm going to be talking a lot about, not a lot about who we are, but a lot about the types of solutions that there are available, a lot about the sorts of issues that GDPR seems to raise, a lot about what those issues really are, and a lot about the solutions and the steps that you can take both in the short term and the long term to prepare yourself for the magic 4 letters. So yes, very briefly, just as a kind of overview, as Marco's already indicated, we have a number of different departments. It's slightly, I think, wrong to see these as individual departments. Our ethos is working together. We don't have siloed departments. Everything that we do is based around, with a mindfulness towards cybersecurity. Everything we do starts from a data-driven perspective. What's the data? How does that work? Where does the data need to get to? From that, we then build and develop tools and services which distribute that data, protect that data, analyze that data depending on the situation that you look at. Obviously, testing is a very key integral part, not only of the development process, of the cloud process, of the security process, so security testing as well as functional testing, but it's also a very important part of working with policies and compliance, and testing those policies and those compliance regimes are robust. Key part of this is obviously data intelligence, being able to, and you'll see this threaded through the presentation today, data intelligence is absolutely at the core of the GDPR, of what's required under the GDPR legislation. And finally, we also offer innovation consultancy, looking at different ways to solve problems. And I think that applies just as much to legislative problems as it applies to technical problems. So I'm going to take you through and I apologize, there are quite a lot of slides. I did originally think I'd just stand here for an afternoon and read the whole legislation to you, but I dumped that idea. There are a few points, though, where it's unavoidable, and I will jump into various pieces of legislation. What I'd like, first of all, is to give you a little bit of a sort of 5-minute overview of some existing legislation. And this is important in the context of what does GDPR try to do? What is it for, and what's the underlying purpose? A lot of articles that are written about it, and a lot of seminars that I've attended, a lot of things where people talk about, it's all about the big change that GDPR is bringing. Actually, in some ways, the change isn't really all that great. In some ways, there's a lot of legislation out there which is already aimed and focused at dealing with exactly the same issues don't worry, I'm not asking for volunteers at any point in the audience, so you'll be fine. So looking at the things that it's designed to deal with, and actually, I think the narrative that comes through is very much that a lot of this legislation exists in one place or another, is applied to one area or another, and this is actually quite a lot about harmonization of things. So I'm going to, having just said I wouldn't, I'm going to read a few quotes from various pieces of legislation, but it's only the first 3 slides, and then we get into the action-packed part of it. So one of the first pieces of legislation that was brought around was in 1981, EU Treaty number 108. And there are a couple of points in here which are quite interesting in framing exactly where data protection legislation has moved since 1981 and where it still is. Okay. So to quote, this convention is the first binding international instrument which protects the individual against abuses which may accompany the collection and processing of personal data. So that's a key thing that we'll be coming back to again and again, personal data. What is personal data? In addition to providing guarantees, it outlaws the processing of sensitive data. So this is different to personal data, sensitive data on a person's race, politics, health, religion, sexual life, criminal record, etc. It also enshrines the individual's right to know what information is stored about them. Restrictions can be overruled by member countries. And then the final thing, which is important here, is it also imposes some restrictions on the trans-border flow of data. So in other words, moving data from one country to another. So all of those were actually enshrined in legislation in one form or another way back in 1981, and they will become very important as we go through. 1998 we had and these are, by the way, these are not exhaustive, nor is this an in-depth legal analysis of these, because as I say, I'm a technologist. But in 1998 we had the UK Data Protection Act, and there are a few phrases in here which again are really important and are reflected in GDPR. Data must be used fairly and lawfully. It must be used for limited and specifically stated purposes. It must be used in a way that's not excessive. It can't be kept for any longer than is absolutely necessary. It must be kept securely. And there is stronger legal protection for sensitive information, such as ethnic background, political opinions, religious beliefs, health, sexual health, criminal records. So again, there's that division of information between the two different elements. Obviously, UK Data Protection Act, specific to the UK. And we'll be drawing comparisons throughout this presentation between the UK Data Protection Act and the GDPR Act, because there are a few things that are significantly different there and have a real impact on how you build and deliver services, applications, and compliance. We also then had in 2008 and amended and built on many times since, 2002, amended and built on many times since then, Directive 58. Now, what's quite interesting about this is, and I may have read too many of these things, this may not be interesting at all, but I found it quite interesting, is a working party analysis of this directory. And what it says here is, the failure to meet the objectives of the directive is on the one hand due to fragmented implementation across EU member states. On the other hand, the rules have been poorly enforced and lawmakers could not keep up with the pace of development in technology. The law has left users vulnerable to the consequences of the extensive use of smartphone apps, online profiling, social media, and the explosion of the internet in general. It goes on to say that there are a whole bunch of things that users are obliged to do, including the concept of anonymizing personal data. And that's also another really important concept that we'll come back to as we go through this presentation. So what they were saying there is and this was also introduced in the notion that if you're storing private information in a cookie, you'll all have seen those websites where it says, yes, I accept that I'm going to be using, I accept that there are cookies being used for this site, and so on. So all of that's kind of building up to the same thing, which is essentially saying that within the framework of all of this legislation, the focus has been continually on very, very similar things to what we're going to talk about today. Personal data, sensitive data, the right to maintain your data only for a limited period of time, the right for that data to be used only for very specific purposes, the right for it not to be transferred across borders unless those borders are deemed to be safe. And the issue has been actually applying that to technology, actually keeping up to pace with everything that's out there nowadays. And so we come to GDPR. I assume everybody probably here is here because they know this bit, but just to kind of set the grounds, the general potato? That's a different one. The General Data Protection Regulation will be in law from the end of May 2018, and it expands and deepens the existing data protection legislation in the EU. Okay, so the important point here, I think, is it expands and deepens the existing data protection. Not new, not designed to kind of bring in a whole bunch of new regulations, but what's interesting, and you'll see this as we go through, is that the requirement and the responsibilities have changed, and therefore it puts onto people from all different firms, especially from a technology firm, a lot of different responsibilities, and also provides a really good moment in time to look back at some of your policies and processes around data and how those can actually be refined to make this simpler. So first change we've got, DPA is implemented through national legislation, and there are many different versions of that within the context of Europe, obviously. GDPR is binding for all member states. while we are a member state. However, as I'll come back to later on, even when we're not a member state anymore, there is a lot of things there. So, jargon. There are inevitably, and anybody who's read the legislation itself, when you read the legislation, there is the legislation which is its own thing, and then there are a whole bunch of what are called recitals that follow on for that, which are clarifications effectively following on from there. And you know what you'll find in there, as you would expect with any piece of legislation, is there is some jargon. So there are three pieces of jargon I just want to call out. The first point is the notion of a data controller. So a data controller is somebody who controls the data. This is not new. Okay, none of these terms are new. These have been around in data protection legislation for the last 25 years or so. But the emphasis has changed a lot, and this is possibly the biggest change to do with GDPR. So a controller is the person who decides how and why data is processed. So they are, as it says, they are the controller of the data. Article 4 of the GDPR states that a controller determines the purposes and means of processing the data. There are a couple of quite interesting examples of controllers. So these are two examples which are taken from the ICO, the Information Commissioner website. And they're not actually in the context of GDPR, they're in the context of the Data Protection Act. But there is a very interesting booklet on that website which allows you to look at various different cases and to specify whether you are a controller or whether you are what is called a processor. And I'll take you through those in a moment. So a processor is the other side of the coin. A processor processes the data. Article 4 states that a processor is the natural or legal person, public authority, agency, or any other body which processes personal data on behalf of the controller. If ever there was a sentence that says nothing, that's pretty much that sentence. Because the key thing here is, what does it mean to process personal data? And that's the area where things get confused. So let's just step back and look at what to process data means. Are you somebody who controls data? Are you somebody who processes data? Because you have different responsibilities under each one. And quite often, and quite possibly, your organization is potentially both. So to process data means to do something to the data. More specifically, any operation or set of operations which is performed on personal data or sets of personal data, whether or not by automated means. That's really important. It's not just about computer data, it's about data. So some examples, practical examples of those. Collecting data, recording data, organizing data, structuring data, storing data, adapting or altering data in any way, retrieving data from a storage system, consulting on data, using data, disclosing data by transmitting it to people, disseminating or otherwise making available data, so for example through a library, aligning or combining data. That's also another key concept and one that's slightly different from previous legislation. Combining data and what that means for what personal data is. Restricting the use of data, erasing data, or destroying data. Those also make you a data processor. So, if I just pick out these two examples, and you know, on this website there are lots and lots of different examples, but I thought these two were quite interesting. So this is a market research company. The bank contracts the market research company. The bank specifies the budget, and that it wants to get a survey from the market research company. So the bank's saying, here are our users, here are the people who bank with us, we're going to give you this data. The market research company has got to go out and they've got to find out some information about levels of satisfaction with that, for those clients with that bank. And the way that it does that is up to the market research company. The bank specifies that these are the people, the bank specifies what they want to be the end result of that, but the bank does not specify how that process happens. So, according to the legislation, the market research company is, the bank is clearly a data controller. They control the original information. They control the list, they have the clients. The market research company is clearly a processor because they are going out, they're organizing, they're collecting data, they're researching. But, and this is a really important distinction, they are also a data controller in their own right. And the reason for that is because they have the autonomy to decide what information they're collecting, how they're collecting that information, and where they're collecting that information from. So in that particular case, you would have the bank, which is the data controller. They would have all of the responsibilities of the controller, which we'll come and see in a second. And you have the process, and you have the market research company. And the market research company is both a processor and a controller of data. So they have double whammy, double responsibility to the other side. And we'll see how all of that integrates a bit later on. Second example is a local authority decides to move all of their public services about housing stock and residents, and rather than keeping the data on their own IT system and having a portal on their own IT system, they move it to a cloud provider. It also has a residents discussion forum, and it has the ability to give residents access to their own records. In that particular case, the cloud provider is only a data processor. They're not a data controller because they're taking the information, they're working with the information, but they are not in any way changing or taking responsibility for collecting that information there. So in that case, the local authority is the controller, has the controller's responsibilities, and the cloud provider is the processor at that point. That distinction is really important to understand what responsibilities you have. And one of the most important distinctions between this and most other legislation is previous legislation has put most of the responsibility for the management, control, security of data onto data controllers. So the bank in my first instance, the housing authority in the second instance. The new GDPR adds a lot more responsibility onto data processors. So data processors, the people who are actually dealing with the data, have a lot of additional responsibility. But actually, when you step back and think about it, in the modern world, if you are processing data, especially sensitive data, the chances are that you are inherently having those responsibilities on you anyway. The difference is, as we'll see, where legal responsibility lies. So one of the first steps to success is being able to identify in each context, and obviously as a client, as a company or as an individual, you will have many different clients that you work with in many different ways. And you may be in some relationships a controller, in some relationships a processor, in some relationships both, in some relationships neither. And a key step is to understand exactly what those roles are. Okay. So what are those roles and responsibilities? Let's start with the controller. The controller should be responsible for and be able to demonstrate compliance with a whole range of different things. This is not particularly different to what's happened before. The rules of lawfulness, fairness, and transparency. So in this particular case, all data's got to be dealt with in a lawful manner, it's got to be dealt with fairly, and it's got to be transparent. So any data that you are responsible for, you have to be transparent in the way that you're handling it. So you can't sell it on to third parties for additional marketing, for example, unless you specifically get the agreement from. Okay. Purpose limitation. This is something that's been slightly cranked up in the GDPR. That means that you are gathering data for a very specific purpose. That is the purpose that you have to get permission to gather it for, and it has to be used in that way. All data has to be specifically used in a very specific purpose. And I'd like to just at this point make one little point here. And this, to me, is key to absolutely everything in this deck or in any discussion about data protection. You cannot limit the purpose of your data and the purpose of how your data is handled unless you know what data you've got and what it's being used for. And that's the most fundamental thing. And I'll keep coming back to that again and again and again. And this is not even really about GDPR or data protection. It's just, you know, how we've all bloomed with lots and lots of data over the years. How do we actually manage that? What's the processes we can put in place? And this GDPR, what GDPR really does is it gives a big push to articulate and manage your data in the same way that you manage your personnel, in the same way that you manage your hardware, your capital assets and so on, in exactly the same way. So data can only be used for the specific purpose it's captured for. So you can't use it for additional marketing, for example. Data minimization. You should only keep the minimum amount of data that you can. So if, for example, you capture a whole bunch of data, but actually to complete the task that you have said that you're going to complete, you only need to keep a small amount. You only should keep that small amount. Data must be accurate. One of the things we'll come to see later on is the fact that you cannot keep inaccurate data about people. If you have inaccurate data about people, they have the right to have that data amended and changed. And actually, there's not a lot of benefit in keeping inaccurate data about people either. Storage limitation, you must define the period of time that data will be stored for. So how long will you store that data for? Okay. And finally, integrity and confidentiality, what it says on the tin, basically. You've got to treat the data with integrity, you've got to keep it confidential, you've got to do all the things that pretty much any organization should be doing to both paper records and to digital records over time as well. All of those things have got to be treated. So these are the responsibilities of the controller. And the controller also has additional responsibilities, obviously, as we'll see going forward, in terms of choosing and selecting who is going to process that data. Okay. So these are not particularly new, but it is important to flag them up, that one of the different things in the new, GDPR is all about accountability. So they are all about somebody being able to come to you and say, okay, as the controller, you're doing all of these. Prove it to me. You know, that's the kind of underlying responsibility. And we'll talk about sizes of organizations because there are differences. So the processor. So just to remind you, the processor is the person who's actually kind of getting their hands dirty with the data. I'm going to quote, I'm afraid, again from the legislation, but I think it's important. Article 28. When processing is to be carried out on behalf of a controller, and basically, by definition, it's on behalf of a controller, because you would never be processing if it's not on behalf of somebody, even if it's behalf of yourself. The controller shall only use processors providing sufficient guarantees to implement appropriate technical and organizational measures in such a manner that processing will meet the requirements of this regulation and ensure the protection of the rights of the data subject. So that's really important because, as we'll see later on, there are some caveats for smaller organizations, organizations of 250 people or less. There are different rules that apply to those organizations. But there are not different rules that apply to a controller. So a controller has a responsibility to make sure that anybody they are employing to process their data is compliant. So it's always worth just considering that in the context that obviously if you are being used by a large organization to manage or process data, they have a responsibility in law, but also obviously a technical responsibility to make sure that those are being, that you are compliant with their GDPR requirements. Okay. So talking specifically here, processors cannot subcontract without a written agreement. So I can't process, you can't agree with me to contract to process your data, and then I go and give it to someone else. I'm not allowed to do that without a written agreement with the controller, with the original owner of the data. And we assume liability for the subcontractor. Processors must have a written data processing agreement with the controller. So it's no longer sufficient to have I mean, this is a contractual thing, so the chances are it's there anyway, but it's now required. Processors can only process data as directed by the controllers. So again, this comes back to that idea that they found so difficult in the meeting group and the e-privacy directive to control, which is that data which is given to one person for one purpose can be repurposed by combining it with different pieces of information, for example, for marketing. So where you have systems that collect vast amounts of unconnected data for marketing purposes, they are now limited in what they can do in being able to cross-reference those data sets in order to then process marketing from there. So there are some fairly significant implications from that one directive there. Okay. You can only process data as directed. So I can't, for example, do some processing on behalf of the bank and then sell that information on. That's the kind of biggest example of what I couldn't do to a data set. You wouldn't do that now anyway, but what you might do is look for patterns, cross-reference those patterns with other data sets, and then use those for a third-party process. That's in a different area now. Processors must delete, return, or data as directed by the controller and provide evidence of having done so. Again, if I'm subcontracting for somebody or I'm contracting as a processor, if my contract is removed, I am obliged to demonstrate that I have destroyed copies of the data. I must enable data audits. This is an important thing. At any point, and we'll talk in more detail about what this means later on, at any point my data could be audited. My data processes could be audited. So I could have an investigation of the controller, and the controller, I would need to be able to provide the controller with information, proof, and depending on the size of your organization, that proof is quite granular about how the data is being processed at each time. Again, how do you do that if you don't know what you've got? Data discovery, the key piece that begins all of this. Notify controller of data breaches. So obviously, if you're processing data, somebody breaks into your data, steals it, and again, don't just think digital. This is also, as I'll demonstrate in a few moments, to do with old cards that are lying on the desk. You are obliged to notify the controller that their data has been breached. As a controller, you are obliged to notify the governing authorities. And you are obliged to take reasonable steps to technically secure the data. Actually, you're obliged to take reasonable steps to secure the data, whether it's technically or not. It might be locking the filing cabinet. Obviously, and most sensitive data, and again, we'll talk about what that really means in a bit. Most sensitive data is going to be secured anyway with best practice nowadays. Data will be encrypted. You won't be kind of sending in emails passwords and things like that. But it's now even more important, and significantly, there is much more emphasis on these people now to take responsibility for that, as well as the controllers. And that's where it makes a big difference to small and medium firms, I think, as well. And again, same thing as going right back to the original 1980s legislation, restrict access to third countries. I cannot just take the data and send it off to my servers that are sitting in, well, I won't pick a particular country, picking in a particular country where I don't want to send my data to, that's restricted. I can't do that. I've got to have guarantees of compliance from those countries. So, how does that make you feel? Pretty much. The reality of that, though, is, again, most of those things, if you break them down and if you know what you've got, most of those things are actually things that are probably being done anyway. Some of them probably require more contractual agreements than there have been before. Some of them require a bit more process. Some of them may require a technical overview. But if you know what you've got it all. Okay. The one thing I did want to pull out here, so I made a funky animation. Data audits. Okay. Data audits, which I mentioned before, are really important because part of what you need to have is a process in place, as I say at the beginning, to understand the data that you've got. Part of the process you need to have is a way of understanding how the data is being managed and changed as you go through the legislative process and as you take on new clients and so on. And so that piece of it is really, really important. And actually, to be honest with you, as I say before, that part of it focuses you in on what are the core requirements of a data-driven business anyway. And most businesses, one way or another nowadays, are data-driven. So the Data Protection Act puts some emphasis on accountability. The GDPR is all accountability first. You are the people who own the data. You are the people who manage the data. It's not a top-down approach, really. Well, to a certain extent. It's a bottom-up approach. It's about what is it that you're doing to protect the data? What is it that you're doing to manage the data? Okay. What time are we breaking? Sorry, I know we're not there yet, but I can't remember. Does it matter what time we break? No, I guess not. Okay, so does it apply to me? If you're in the EU? Yes. It does. Simple answer. If you're about to leave the EU? Yes, it does. if you offer goods or services into the EU. So if you are dealing with data that is specific about an EU citizen or citizens, or you're offering goods or services that can be consumed in the EU, then it does absolutely impact you. And realistically, that's an awful lot of companies, who are not in the EU, who are likely to be affected in some way around that. And it's also worth saying at this point that there is different legislation being introduced around the world. China has new legislation about being able to store Chinese information out of China. Russia has legislation about whether or not you can store data outside of Russia. There are, and those have been introduced over the last 2 years. Chinese one comes into force next year. And there's no way that those are going to be the only countries that do that. So the same policy applies, to EU or non-EU countries. You need to know what you've got. You need to know where it is. You need to know what it impacts from there. Okay. But there are some exemptions. It's not required for data processed for national security. So if you're processing information for a national security purpose, you are exempt. Again, there are some limitations to that as well. But if you're processing it for purely household data, you are exempt. Now, just to one of the recitals I mentioned, which is the clarifications I mentioned, actually is specific about what household data is. And it says, this regulation does not apply to the processing of personal data by a natural person, as opposed to an unnatural person, in the course of a purely personal or household activity, and thus with no connection whatsoever to a professional or a commercial activity. Personal or household activities could include correspondence, holding of addresses, social networking, and online activity undertaken within the context of such activities. However, the regulation applies to controllers of process which provides the means for processing personal data for such personal or household activities. So if you're on Facebook, your data that you're putting into Facebook at that point, you're not liable for that, unless you're libeling someone, but you are, as Facebook or another social network, liable at that point as well, responsible at that point as a processor. So purely household data, well, that's what it means. Okay. Law enforcement data, obviously, if you have data that's being used for criminal investigation, that's exempt. And also, if you're dead. Or data pertaining to dead people is also exempt from this. Again, there are caveats to that, but as a broad stroke in there. There are a couple of other things related to does it apply to me, which are in Article 30 and Recital 13. Pretty exciting life I lead. Okay, so Article 30. The obligations referred to in paragraphs 1 and 2, and these are very specific obligations about data protection officers, which we'll come to a bit later on. But I want to call this out at this point. Should not apply to an enterprise or organization employing fewer than 250 people, unless the processing it carries out is likely to result in a risk to the rights and freedoms of the data subjects being the people about whom you're connecting data. The processing is not occasional, and that is a really good example of a, what does that mean? And the processing includes special categories of data. Okay, so obviously there are two things there. What are the special categories, and what does not occasional mean? So Recital 13 is the bit where somebody's obviously said, hey, what does that mean? Let's get a bit more information. So to take account of the specific situations of micro, small, and medium-sized enterprises, the regulation includes a derogation for organizations of fewer than 250 employees. With regard to record keeping, and that's an important caveat, it doesn't exempt you from GDPR on the whole. It exempts you from some things around record keeping. You still got to know what you've got. You just don't have to formally record it. Although I would argue that actually you do. In addition, the union, institutions and bodies and member states and the supervisory authorities are encouraged to take accounts of the specific needs of micro, small and medium-sized enterprises. So that says even less than the one above it, effectively. It doesn't really say very much, except that if you're a small organization, you're likely to be treated with a bit more sensitivity than a large organization, okay? And we'll come back to what that specific derogation is and which bits are not relevant a little bit later on. But just to be aware that there are differences between the 250 size organization and the large organization. I also want to pick up what the special categories are, because this is, again, this comes back right to the beginning, the categories of data that you are obliged to be fully in compliance with the GDPR on, even if you're only a two-person organization. And that's if you're processing personal data which reveals racial, ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, processing of genetic data, biometric data, data concerning health or data concerning a natural person's sex life or sexual orientation. So if you're processing data around any of those, whatever the size of your organization, you are obliged to follow every single piece of the GDPR. Okay. So is this all data? Do we have to worry about this for all data? Well, the answer is no. Just personal data. And what does that mean? What that means is we're going to have one final piece of jargon. So this is the actual definition, and then I'm going to break it down into various examples of what this means, because this is in many ways the most important paragraph of the whole legislation. Because what seems to spell out fairly sensible things, when you actually drill down and you look at what data do I really have, you'll find that a lot of this, a lot more than you expect, applies to the data that you think. Typically, personally identifiable information is deemed to be name, surname, credit card number, email address. Actually, there's a bit more to it than that. So personal data means any information relating to an identified or identifiable natural person. An identifiable natural person is one who can be identified directly or indirectly. Big red letters. Directly or indirectly. In particular, by reference to an identifier such as a name, an identification number, location data, an online identifier, to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that person. So in other words, either directly or indirectly, the information that you have can be used to tie that information to an individual. That is personal information. And that is the huge change. That is the bit, all of the other stuff in here is very much a kind of compliance. It's a legal requirement. It's something that a process can be put in place. But this bit has impacts on an enormous number of things, which I will now go through and explain to you a little bit in more detail. So I just want to pull out these few areas. There are lots more. Identification number, location data, online identifier, genetic data. So those are all specifically defined in there. So let's look at those categories. And remember, this is directly or indirectly. So an identification number. An identification number can be a national insurance number. Okay? It can be a bank account number or something like that. It can also be in an internal system. It might be your unique user ID that's used in a particular system. And how does that work? Let's say, for example, there is a technique which we'll talk about a bit later on called anonymization, which allows you to take data and strip out names and usernames and emails, and then you've got anonymized data. You've got, I might be number 12646 in this system, but that doesn't tell you anything about me. Or does it? If I take that data for 12646 and I look at the various actions that 12646 has performed over the last week, and I match that up to other data sets that exist, it's not that difficult to work out that 12646 is in fact Matt Wicks, and he's been doing whatever it is he's been doing, and identify no kind of good examples that I could speak about came into place there. But it's not that hard to put it in there. So actually having an identifier that is unique, even though you're not directly tying it to an individual, can indirectly be tied to data. And I'm going to pick out some other pieces about that in a moment, give you a real-world example of that. What's important here, though, is that something that's a bit of a different thing here with the identification number. In almost all the rest of the legislation, the idea is that it's broadly the same throughout the EU. With the identification number, there's a specific clause which allows member states to apply different conditions to the use and storage of a national insurance number. So you might build a European-wide system or have a European-wide process, but you may find that in this particular case, Portugal requires a different level of security for the handling of their national insurance numbers versus Ukraine, for example. So those are well, Ukraine's not a good example, versus England. So those are examples of where the identification number is relevant. Okay. Now this one is really interesting. And obviously this goes back to the quote that I read out at the beginning from the working committee, where there were lots of examples of the successful implementation of previous legislation failing to come through because the legislation, and more importantly the enforcement of the legislation, wasn't keeping up with smartphone apps and things like that. Obviously, if I'm storing personal data about you, and within that personal location data, it becomes personal data if it's related and able to identify a specific person. So if I'm saying Matt Wicks was at the Citizen M on whatever day today is, 31st of, happy Halloween everyone, the 31st of October, you know, that's very specific and very clearly personal data. But surely, if I take that information, wipe out all of the names of the people and just use that as an anonymized data set, then in that case, that can't be personal data, can it? Actually, it can. And so let me read you this example here of some research that was done by MIT. So what MIT did was they took a data set which had all the usernames and all the names of people removed. And they took a data set of 1.5 million people within a territory of 100, within a radius of 100 kilometers. They took the data set for over 15 months. And by running a very simple analysis remember, this data has no people's names in it, it just has location information, they were able to identify 95% of the population from 4 location points. So they only took 4 location points, and from those 4 points, they were able to identify 95% of the people. Now, obviously, they're combining it with different data sets, working out, okay, this person does this journey a lot, they work here, they live here, you know, you're able to push back through that. You only need two location points to get 50% of those data subjects, which is actually quite extraordinary to be able to get to that level. So under GDPR, all of that data is personal data. Okay, and that's where you can read about that particular study if you want to. It's from Nature, and we'll make these slides available online after. Okay. Personal data, that's what I look like first thing in the morning. Personal data also includes, according to Recital 30, it includes these things. And this is a lot of this is new. So typically, if you think about it, the way that a lot of marketing tools work now, the way that a lot of online marketing works, the way frankly that a lot of applications work, is that they capture information about you, and they don't need to capture your name. They can identify you from your address. They use cookies and so on. So all of these things are now regarded as personal data. So this again is from Recital. So this is from a clarification. Internet protocol addresses, cookie identifiers, RFID tags, so the sorts of tags that you get in badges when you're walking around and you can swipe them and well, in fact, damn, my prop didn't work. Okay, one of those. They leave traces, which in particular, when combined with unique identifiers and other information received by the servers, in other words, indirect, not direct, can be used to create profiles of natural persons, like my friend here, and identify them. So effectively, what we're saying there is, it's no longer enough to say, yeah, I've got a few usernames, I can wipe them and we'll be fine. There's a lot more to it than that. Okay. Last piece on personal data. There is some specifics around genetic and health data. Again, these are things that are obviously personal data, but again, they fall into a category of more sensitive data that have a higher degree of attention paid to them. In particular, chromosomal DNA or RNA analysis, and then here, a number, a symbol, or a particular assigned to a person. So effectively, if you go in for treatment at any point to a doctor or hospital, a number that's assigned to you at that point, even though it may not be tied back to you, is regarded as personal information. Now again, the NHS, obviously they've dealt with this for a long time, but it's also important to know that this is all relevant there. And more important again, and I come back to the same thing, if you don't know what you've got, you don't know how it combines with other bits of information. If you don't go through the process of identifying, what of your data is actually directly attributable to a person and what of your data is potentially attributable to a person, that's something that's an important step here, I think. So, the Data Protection Act includes some elements of personal data, the most obvious ones, the most common ones. GDPR adds in location data, online identifier, genetic data, and of course makes a big thing about the combination of data and data sets at this point. Okay. But we're okay. We're not modern. All our data is on cards in the cupboard. We didn't use these computers or anything like that. We've just been putting it in the filing cabinet. What are you worried about? If the data is personal and forms part of, or is intended to form part of, a filing system, it is still covered by GDPR. So what that means is, if it's in a filing system of any nature, or if it belongs to a filing system but you've put it in the post, or you've left it on a table, that's also fair game here. So PricewaterhouseCoopers provide a privacy and security enforcement tracker every year. And I want to read, and what this does is, it's a very interesting document, if you have a lonely weekend. And what this does is, it breaks down all the various prosecutions that have happened over the last year, and breaks them down into categories of things where there's been a fine, where there's been an undertaking, which is effectively an organization has had to undertake to do something, or where there's been, in fact, a criminal prosecution. And there are two that I want to pull out here to illustrate. There are lots around digital, but there are two that I want to pull out here to illustrate the fact that it's not just about electronic data. And again, these are under the DPA, but the same will apply to GDPR. And as you'll see when we talk about the fines for GDPR, they're significantly more. So two very quick ones. Hampshire County Council, 10th of August 2016, received a £100,000 fine. And this was because documents containing details of over 100 people were found in the building after they'd moved buildings. They'd vacated the building and those details were found following on from that. There were some mitigations against that in that they went back in, they collected them, that the data wasn't highly sensitive, that the council referred the incident itself, but nevertheless, £100,000 fine. It's a lot of money for leaving an envelope full of, or a filing cabinet full of fines in there as well. The second one, you've probably also heard of this. This didn't result in a fine, but it did result in an undertaking, which was a police force. There was a handover file, which contained officer and witness statements relating to an incident involving imitation firearms and drugs, was lost. The file was placed in the internal post, but arrived at the incorrect destination. Ouch. Most of the documents were recorded electronically and so could be retrieved, although certain witness statements were recorded on paper, and so some witnesses had to replace them on a second statement. The data controller had no record of whether the staff member involved in the incident had received data protection training. It was further discovered that data protection training was only provided by staff for the last 10 years, and no data protection training records were maintained, and only 30% of the staff had been on an electronic refresher. Now, and they didn't get a fine, but they were required to undertake a whole bunch of things to change. The point there is that exactly the same thing applies to GDPR. If you have information that fits into the personal category, the personal status category, you've still got to go through, you've still got to follow the same processes, the same principles. The fees are enormously larger than for the DPA. But, same thing. How is it that a filing cabinet of data got left behind? Chances are it's because they didn't know they had it. How is it that witness statements were only partially placed into electronic format and some were not? There's a process broken there in some way as well. Okay. So, all of that sounds like a lot of hard work to kind of keep on top of it. Is it? And I'm going to tell you why it's not quite such hard work in a bit. Is it worth the effort? Well, the answer is penalties of up to 20 million euros or 4% of annual global turnover, whichever is higher. That is a lot of chips. So basically, it is an enormous amount. Now again, just to kind of frame this back, remember the sections on, for smaller micro companies, mid-sized companies, obviously there is a different process involved here. You know, there is a requirement in the legislation itself to take account of those companies. But legally, that is the potential, that is an enormous amount of money. So that's a big change. The DPA has a maximum of 500,000. GDPR has a maximum of 20 million euros, pounds, so it's not quite the same, but there. Okay. Okay. So let me keep going because there's a lot more to keep through. So what do I need to do? First of all, as I keep saying, data discovery. Know what you've got and know what you've got in context. And that second one is, again, really important. Make sure you know what data you've got and make sure you know how it relates to other data sets you've got. And also, make sure you know what you've given to somebody else as well. Because remember, there is extended liability for you if you've given data onto somebody else. Okay. What time are we breaking? 3:30. 3:30, okay. Perfect. Classify your data. So this comes back to the same thing. It's, you know, when I talk about know what you've got, I'm going to explore that a little bit more in depth now. But being able to classify your data is really, really important. Because actually, when you start digging into it, you start to find some interesting things. Classifying your data means classifying it as personal data, classifying it as unique data, so data that can be combined with other data sets to identify someone even if the personal data is removed. Sensitive data, so that's the stuff around ethnic origin, around sexual orientation, around health and so on. And then here's an interesting statistic. The notion of classifying your data was actually introduced in the Official Secrets Act in 1889, so it's been around for a long, long time. A company called Veritas done some interesting surveys, and over 25% of employees store personal data on work devices. Now, obviously, there are internal policies, but we're talking about companies that are, you know, if you're talking about a small to mid company, the chances are that there is some storage happening of personal information. Larger organizations tend to be slightly better at this. From personal, legal, and identification documents, 57%, photos, 57%, 47% of music, down to videos and games. That's on your work systems. That's on the systems that you as a company are responsible under GDPR for. The Veritas Global Databerg report, I love that word, the Databerg, finds 85% of stored data is either dark or redundant, obsolete or trivial. Now, I don't know how they arrived at that statistic, and it's free to download, to analyze and bring out. But what's quite interesting about that is if you think about what we've been saying so far, a lot of what we've been saying is in order to be able to manage your risks, in order to be able to achieve what you need to achieve within the context of GDPR, you need to know what you've got, and you need to understand what you've got, you need to classify it. But actually there's a huge additional benefit to that, because actually if a lot of the data that you're managing is redundant or old or just, you know, has become redundant over time. Knowing that in and of itself is a commercially valuable piece of information as well. Knowing that actually, we are spending a lot of money maintaining data that now has no relevance, and we have now classified that and identified that. That's of, I think, some commercial benefit as well. Okay. So I'm going to give you an example now of a data directory. Now there are lots and lots of different ways of doing this. There are lots and lots of different. Well, let me open the actual file. In fact, so you'll see there are two different types of document that I'm going to refer to. This is simply a very simple example. Oh, sorry, I forgot I was. So this is a very, very simple example. When we go into companies and do analysis, we use a slightly different and much more electronic example than this one. But this is a freely available example from the web, which is from the National Archives. And this is a really good, I think a really well thought through, but very low tech, very simplistic piece of organization that can be done in most organizations. So asset number ID, the name of the asset. So what is it that what is the bit of data that you're doing? Is it a system? Is it a filing? Is it a file? Is it a single document? Is it a collection of passports that you've taken a record of? Or is it an all-functioning application, and therefore which bit of that application is it that you're trying to work down? Is it a mobile app that some third-party contractor built for us 6 years ago and we don't really know what it does or what information it's capturing? What is it? Being able to identify that asset. And that's where this falls down slightly, and we have a much more granular way of looking at this. But in the framework of this conversation, this is the top-level information that you need to be aware of in one form or another. What does it do? What is the purpose of the data? Where is the data saved? On John's desktop. Who is the owner of that data? And that's a really important concept which we'll come on to later on. The notion that all data has an owner. Because legally, within the framework of GDPR, somebody is responsible. Somebody is accountable for that data. And that's the piece that we'll talk about. And particularly, in fact, Crystal, when she speaks, we'll be talking about as well. What's the volume of the data? How much data is there? Is it personal? Key question. Is it personal? Now, again, I think you need to break this down actually much further than this into, is it personally identifiable right now? Could it be combined? Because you treat those differently. Who has access to it? Who's it shared with? So who has it been disseminated to? Because again, I own the data. If I've disseminated it to other people and they've misused it, where do I sit in that framework of contractual requirement? What format is it in? How long is it going to be retained? Again, this is another requirement. How long is your data actually going to be retained for? 70 years in this case. And what are the risks or impacts? So there is a risk, if it's stolen, of a loss of confidentiality, a loss of availability, a loss of integrity. And in this particular case, although again, I think the yes-no nomenclature here is a little simplistic, but effectively, is it a key asset? So, as the first step to being able to really identify what you want to do and how you want to process your data, you need to know what you've got. Now, obviously, this is a huge undertaking. It's a significant piece of work to be done. But I come back to the same point of, as an organization in the modern world, the data that you have and the data that you manage and the data that you don't need, those are all commercial assets that need to be figured in. And GDPR is a huge impetus to be able to do with that. Okay. So the data directory or data record or data page, or it has various different names. It doesn't really matter what it's called. There are tools that will allow you to do this. We provide a service that will allow you to do this. Either way, being able to collect and categorize your data is really, really important as a first step. Okay. So, steps to success, data discovery. Record all data processes that occur. So, recording the data, great. We know we've got all of these different pieces of information within the organization. We know that we can put our finger on where they are, and we know who has access to those pieces of data. What we've found time and again is actually a lot of that process is down to speaking to a few key people. A lot of that process is looking at a few key systems. A lot of that process is also, it's kind of like when you start looking at that, you start to turn out, okay, these are the risks as far as GDPR is concerned. We've identified that these files that we've got here, or this system that we've got here, it probably isn't compliant, so we now know what we need to be able to do with it. So effectively what you're doing is you're creating a menu. You also need to understand the processes that are applied to that data on an ongoing basis. Is it data that just sits there and is there and is archived, or is a billing reference or stuff, or not a billing reference, or is archived, or is just a reference? Or is it a billing reference, or is it a training reference, or is it data that's constantly being processed? Because if you go back to the original definition of a processor, if you're a company of 250 people or less, you don't have to comply with all of the record-keeping results unless you are regularly processing the data. So there's a really important distinction there. Okay. And that's where we come to the second document, and this one is a bit more explicitly required by the GDPR. So the data discovery is our view of, what is it that we've got, what is it that you've got, what is it that you can put into your organization, how can we help you, or how can you help yourselves understand your risks. The data register is a requirement of the GDPR. The data register, each controller, and where applicable, the controller's representative, shall maintain a record of processing activities under its responsibilities. So if you remember, I pulled this one out earlier. This was the one about the 250. And the first part of it is the obligations referred to in paragraphs 1 and 2 shall not apply to blah, blah, blah. This is the bit that there is some exemption for smaller organizations. The notion here is you, certainly as a large organization, must maintain a record of all processing activities to any personal data that is within your organization. Now, what that looks like, there are lots and lots of templates you can purchase online. As an example, there are lots of services that are provided by us, amongst other people, that can enable you to build this. But the key thing that you have to understand is what goes in it. Contact details, obviously. And whose contact details is important. We'll talk about the role of the data, the DPO in a moment. But if you don't have a specific DPO, you still need to provide contact details. Again, it's the concept that keeps coming back from GDPR, the concept of accountability. You are accountable. Who is accountable? Not your company, you specifically. You are the person whose name is on this list here. You are accountable. Okay. Of course, the company is ultimately accountable in this case, but the purpose of the processing. What is the data being processed for? Is it for billing? Is it for training? Is it for marketing purposes? Is it for sending out to invite people to an event? What is the purpose behind that? Is it for a film shoot that you're processing the data? Everything has to be categorized. A description of the categories of data and categories of personal data. And we'll come on to some of those categories a little bit in a moment, and I'll give you some demonstrations of some of these. So these are what type of data is being collected and what type of personal data is being, processed. Categories of people to whom it will be disclosed. Is it just going to be disclosed to people who have been invited to the event? Is it going to be used for further marketing? Is it going to be used for building up a database? Is it going to go to the directors? Is it going to go to the marketing department? Those sorts of pieces of information, really important. Details of where the data will be transferred out of the EU and the safeguards taken to allow this. Now this one is going to be, for all of us who work in the UK, something we need to give serious consideration to, because the chances are there's going to be a lot. I mean, leaving aside any global footprints we have, for us as an organization, we do work in, we have offices in Dubai, we have offices in New York, We have offices in Pennsylvania. You know, all of these places we will want to transfer data to, and this becomes important. But we also have a core office in Lisbon in Portugal, and we will be transferring data between those two. And each time we are supposed to keep a record of this. So again, all of those things are really important when you're taking data out of the EU. Where is it being transferred to? Is it being transferred to a safe place? Same thing again, how long is it being retained for? And a description of the organization, so the policies that you put in place and the technical security measures which are around that. Are you encrypting the data? Is it going across HTTPS versus HTTP? If you've sent it across in a van, was the van locked? Sorry, that was the best example of a non-digital one I could think of there. So to give you some quick examples here, contact details, yes, very straightforward. The purpose of the processing, to provide a statistical analysis of the previous month's usage of a website or a video stream or something like that, in order to provision marketing tools. What categories of identity are being used? So I'm sending out an online identifier. So that's the unique number I'm using to capture your background. I'm actually also capturing some generalized location details because I'm using Google Maps. Sorry, I'm using Google Analytics. So I know that you're in London. So there's some information there. And I'm also capturing the URLs that you visited to get to that web page. So I'm building up a profile of number 74 who's in London and has previously been looking at Ferraris. So I know it's probably Marco. Okay, so categories to whom the data will be disclosed. Who am I going to send this information to? I'm going to send it to the system owners, the people for whom we built the system, because they want that information. I'm also going to send it to the internal stakeholders, the people who I'm working with on the project, to make sure that they know, to make sure that they are seeing the analytics. I'm not going to send it outside of the EU. I'm going to retain it for 1 year. And there's a whole bunch of encryption measures that I put into paste. I had a penetration test done on the site 6 months ago. I'm using Intription, which is a magical version of encryption, and something called pseudonymization, which I'll come on to in a moment because it's so difficult to say. All of that information is captured for the various different data processes I do, whether that's billing, whether that's analytics, whatever it is that's doing it. Now again, of course, this seems like a huge overhead, but first of all, remember the 250 size item. Also remember, if you've gone through that initial process and you know that you have this data here from this system, this data here from this system, this data here from this system, actually, most of the time, as part of that process, you are by default saying, and it's used for this, and it's used for this. So you're actually building up that information at that point. And again, it's very unlikely in most organizations that you have no idea what data you've got anywhere. It's simply an administrative task of pulling all of that together and categorizing it in a way that's. But again, think about how useful it is. Think about how useful it is for identifying your risks and how useful it is for identifying where things need to have more attention, or where, and this is what we've found time and again, where you've had organizations where you have processes that have grown up in different parts of the organization. Actually, by bringing this together, you can harmonize a lot of processes and streamline things. Okay. So we come to the role of the DPO, the Data Protection Officer. The Data Protection Officer is something that is specified in law by the GDPR. The Data Protection Officer must be appointed for all public authorities and where the core activities of the controller or the processor involve regular and systematic monitoring of data subjects on a large scale, or where the entity conducts large-scale processing of special categories of personal data, those special categories that we talked about beforehand. The controller and the processor shall ensure that the Data Protection Officer does not receive any instructions regarding the exercise of their task. He or she shall not be dismissed or penalized by the controller of the processor for performing his task. The Data Protection Officer shall directly report to the highest management level of the controller or the processor. So I think one of the things that's kind of become a myth of the GDPR is that you have to have a DPO, whatever size your organization is. That's not true. But what is true is that the responsibilities and functions that that officer or that role has are very necessary in order to carry out a lot of the pieces of GDPR implementation that actually are necessary. So there is a huge requirement there. And again, I come back to the same thing. This DPO role, it's not just about GDPR. It's about your data commodity and how you use that, how you manage that, how you track that, how you commercialize that. And that's a lot of what this role can allow you to do. So let's look at the actual responsibilities that are enshrined in the legislation. To inform and advise those handling data of their obligations. Really important one. Somebody within an organization, and again, it doesn't matter whether it's a DPO or whether you are just taking on this responsibility generally, you need to have a way of disseminating to the rest of the organization their responsibilities for handling data. You cannot just take a photocopy of your passport and save it on your hard drive. If it's a business hard drive, we become liable for that. You cannot just download and store all of your Facebook friends' information on the local machine because, again, sits within the purview of the company. You have to follow the policy of advising X, Y, and Z of a use of their data. You have to make sure that everybody who is touching data at any point within an organization is aware of their responsibilities. Again, this is not rocket science. This is not something new. This is something that probably is happening around and about in different organizations in different ways. It might be that actually it's the IT department performing that function at the moment. It might be that actually it's just a policy that's sitting in a drawer somewhere. It might be even that it's the HR department who's performing this role. Doesn't really matter. The fact of the matter is there is a requirement for this to be performed, to be accountable, to be traceable, and in larger organizations to be a single or group of people who are there. To monitor compliance, raise awareness, and train staff. It's a really important thing. Obviously, the whole idea of the data record, the whole idea of the data of the data register, this is not something you do once and that's it. Over time, applications develop, filing systems increase, processes change. It needs to be monitored and adhered to the whole time. It's something that's going to affect every part of any business's life forever, for now. To raise awareness within an organization of that and to train staff in that. Now again, that doesn't mean they have to actually train the staff. It might mean that you want to discharge that functionality by bringing in an organization to provide that training for you. It might mean that you want to have a seminar with all of your staff in order to provide that. It might mean that you simply go back from today and disseminate some of that information and dig a bit deeper yourself. Doesn't matter, but there is a requirement for your staff to be trained. Not having staff trained is not an excuse for non-compliance of this legislation. To provide advice for data impact assessments. I'm going to come on to those in a moment. Those are really important. And those are things that from a technologist point of view are also something that we inherently do, but it's really interesting to see it being brought into the legislation in this way, and it's been again in the DPA for a while, in this way so that they become part of the development process of a product. To cooperate with the supervisory authority, again, if you are a controller and there is an issue that you need to raise, you are required to cooperate with them. If they want to audit your process, again, you're required to. To be a point of contact for external authorities, not much to be added in there. Okay. So, one of the things that's required is the data impact assessments. The data impact assessments are effectively something called something which is designed whenever you're doing something new with data. You effectively are producing like a risk assessment for that data. So it becomes part of your lifeblood, part of your design process of any application from our perspective, part of your design process of any process that you're putting into place, and also part of any new HR process. And these links here are actually taken from the ICO website, which has a privacy impact assessment, which is kind of similar. And this again is a free download, the Privacy Impact Assessment Code of Practice, which specifies a number of different steps. And I think these are equally applicable to a data impact assessment as well. There are some additional things with the data impact assessment as regards being able to link that data to other data sets. So they say that you need to identify the need for an impact assessment. You need to describe the information flow, so how information goes, whether it's around the organization or whether it's around an application. To identify the privacy and related risks. So again, it's back to the data register that I showed right at the beginning, the data record that I showed right at the beginning or halfway through, where you're saying, okay, this is private data, this is a risk. Identify and evaluate the privacy solution. So what is being done to keep this private? And again, we'll talk about privacy by design. To sign off and record the PIA, the Privacy Impact Assessment outcomes. And Crystal will talk a lot about this when she talks, which is, one of the structural things with the organization is to make sure that if you're doing this impact assessment, somebody in authority, the DPO probably, is actually saying, yes, this is fit for purpose, we agree for that, I am prepared to be accountable, again, that key word, I am prepared to be accountable for this process. To integrate the outcomes into the project plan, otherwise there's not much use in doing it at all. And obviously to consult with internal and external stakeholders as needed throughout the process. To make sure everybody is part of the privacy spiral. Okay. So some more steps to success. To appoint a DPO or at least a data owner, somebody who can stand in as a DPO or can take that responsibility within your organization. To carry out data impact assessments as and when needed, either internally or externally. And again, obviously, this is something that we're happy to offer as a service. To make sure all staff are trained on data handling, critical from day one, and not just trained. If you remember the example I gave about the police and the lost witness statements, trained and retrained, trained and retrained. Everything changes all the time, especially to do with technology. You've got basic things, they need to be kept up to date, they need to be refreshed, they need to be self-assessing that they're doing these things. And make sure all policies are in place and are articulated, by which I mean are made clear to people around. So, with that in mind, I'm going to ask, have we got Crystal available? Is she ready to? No? Okay. Okay, just after the break. So do you want to take a break now, or do you want me to carry on? Yeah, no, this is a good point for us to take a break, I think. I'm running about 15 minutes ahead of schedule. But I think that when we come back, I'll hand over to Crystal Pennington, who will talk about NeoRM, which is a tool designed to monitor accountability and compliance. So she'll talk for 25 to 30 minutes. But this is probably a good place for us to have a break. There's sodas, drinks, coffees, teas.